You might think your divorce is going to be simple. You're not angry. You've had a few conversations. Maybe you've even agreed on who gets what. But here's the truth. Every week we get calls from people who thought they had it all figured out until everything fell apart. One disagreement, one outside opinion, one unsigned document. And suddenly they're in court, spending time, money, and energy they didn't plan for. So how do you know which path is right for your divorce? That's exactly what we're going to try to figure out today. Because whether you're looking for something uncontested, collaborative, or you already know it's going to be contested, there is a right process. And if you get that right, you can save yourself months of frustration and thousands of dollars. I'm Vanessa Vasquez de Lara, founder of the Vasquez de Lara Law Group, and I've been practicing family law in Florida for over 20 years. And in that time, I've seen just about every kind of divorce you can imagine. Quick ones, long drawn out one, divorces that started amicable and turned into a war, and the ones that looked messy on paper but ended up resolved with dignity and respect. The one thing they all had in common, at the beginning, people didn't always know what they were walking into. Empathy and intent. And look, I get it. You're not a lawyer. You don't do this every day. This isn't just paperwork to you. It's your life. So I'm not here to tell you what kind of divorce you should have. I'm here to help you figure out the best path forward before you find yourself overwhelmed, confused, or blindsided. Because we've had clients come to us after trying to do it on their own, only to realize they'd made agreements that weren't enforceable, or they trusted the wrong advice from someone who knew a guy, or they assumed they were on the same page until they weren't. I don't want that to happen to you. So if you're willing to take a few minutes, I'll show you the real differences between uncontested, collaborative, and contested divorce, and how to tell which one fits your situation best. Because once you know your path, everything else gets easier. There are 3 main paths to divorce in Florida, and choosing the right one can save you thousands of dollars, months of stress, and in some cases, your peace of mind. Let's break them down. Let's start with the simplest option, uncontested divorce. In Florida, a divorce is considered uncontested when both parties agree on everything. If you and your spouse are already aligned on those decisions and you're both willing to sign off, then uncontested divorce may be the right path for you. But even then, it's important to know what the process actually looks like. One person will need to file the initial petition for dissolution of marriage. That's the document that officially starts the process. It must be filed with the circuit court in the county where either of you lives. Even if you've agreed on everything, the legal paperwork still has to follow Florida law, especially when it comes to child support or financial disclosures. Both spouses must exchange something called mandatory financial disclosure, although some of those things can be waived. That's going to include tax returns, pay stubs, bank and retirement account statements, credit card balances, and property values. Even in uncontested cases, this step matters because an agreement based on incomplete or inaccurate information could be challenged later and might not hold up. Next, you'll create a marital settlement agreement, a written contract that lays out exactly what each person will get or give up. If you have kids, you also need a parenting plan that addresses time sharing, holidays, communication, and decision-making authority. Here's where a lot of DIY divorces go wrong. We've seen people copy language from the internet. Let's talk about ChatGPT. Sign a few forms and then come back a few months later because something was not enforceable or they misunderstood what they signed. It's not just about having an agreement. It's about having a valid, complete, and enforceable agreement. Once the agreement and disclosure are complete, they're submitted to the court. In most counties, a short final hearing is scheduled, or sometimes everything is simply submitted. Only one spouse may need to attend. The judge will ask a few basic questions to confirm residency, that the marriage is irretrievably broken, and that the agreement is voluntary and understood by both parties. Then, if everything's in order, divorce is finalized, usually within a few weeks. Even in the most amicable cases, we've seen people get tripped up by missing required documents, using outdated court forms, leaving key financial or parenting details out of their agreement, not realizing they were waiving important rights. One former client said in their review, "We started off thinking we could handle it ourselves. Then we hit a wall with the parenting plan. Vanessa and her team stepped in and made sure everything was done right without turning it into a battle." If you want an uncontested divorce to truly work, you need clarity, complete paperwork, and a written agreement that protects both parties, not just for now, but for your future. We always tell clients, amicable does not mean informal. It just means you're trying to work together, and we're here to help you do that in a way that protects everyone involved. Collaborative divorce. Now, if you're not quite in full agreement, but you and your spouse want to stay respectful and out of court, there is a structured way to do that with support, privacy, and protection for both of you. It's called a collaborative divorce. Collaborative divorce is a structured, private process designed to help families resolve divorce issues respectfully and transparently without litigation. But collaborative isn't just about being friendly. It's a legal process with clear steps and formal agreements. Each spouse has their own collaboratively trained attorney, someone who's committed to keeping things out of court. The team also includes a neutral facilitator, often a licensed mental health professional, who manages communication and helps keep the process emotionally safe and productive. And a neutral financial professional who helps organize documents, run scenarios, and make complex financial issues easier to understand. Everyone signs a participation agreement upfront saying, "We will not go to court. We will be transparent with information, and we will work in good faith to find solutions." If the collaborative process breaks down, both attorneys must withdraw. That means everyone has skin in the game to make it work. The process unfolds over a series of joint meetings, usually 4 to 6, depending on the complexity of the issues. In the first few meetings, the team identifies key concerns and goals, gathers unnecessary financial documentation, builds a shared understanding of the family's needs, especially when children are involved. Then, through structured discussions, you'll work towards a fair parenting plan, a realistic plan for asset division, decisions about alimony and child support, and anything else that's needed to finalize your divorce. Agreements are reached through facilitated negotiation, not threats and not ultimatums. And once everything is settled, the attorneys prepare and file the final paperwork with the court. There's usually no hearing required. The judge reviews your agreement and signs off. Collaborative divorce works because it is solution-focused, not blame-focused. Instead of fighting to win, both parties work to create a future that works for their family. That's especially valuable when there's kids involved. We've had clients tell us things like, "I didn't think we could get through it without court, but the structure and the people guiding us made it possible." Another said, "It was still hard, but I felt respected, supported, and heard throughout the process." Collaborative divorce also protects your privacy. Nothing becomes part of the final public record except for that agreement. That means no messy court transcripts or accusations, just a documented resolution. Collaborative divorce isn't right for everyone. It doesn't work when one party refuses to participate or negotiate. There's ongoing abuse or dishonesty, or one side just wants to win at all costs. But if you want to keep children out of the conflict, value your privacy, and are willing to negotiate in good faith, then collaborative divorce can offer a healthier, more cost-effective way forward. We'll help you build a team that fits your family's needs and guide you through every step. But when collaboration breaks down or was never possible to begin with, there's still a process for protecting your rights. Let's talk about contested divorce and what it really means. Sometimes, despite your best efforts, things just don't work. Maybe you've tried to talk. Maybe you've sent proposals or even tried mediation. Or maybe your spouse is avoiding, manipulating, or outright refusing to cooperate. When that happens, when an agreement is not possible, you need the structure, protection, and authority of the court and a judge. That's what we mean by a contested divorce. A contested divorce does not necessarily mean a full-blown trial. It just means that there's unresolved issues that need to be decided by a judge. That might be how parenting time should be divided, whether alimony is appropriate in your case, how to divide a business or a piece of real estate, or what to do when one spouse hides or refuses to disclose financial information. Contested divorce gives you the legal tools to protect your rights and to ensure that the outcome is not based on pressure, manipulation, or guesswork. Let me walk you through what actually happens. One spouse starts the process by filing a petition for dissolution of marriage with the court. That filing outlines the key issues that need to be addressed. The other spouse then files an answer and sometimes a counter petition if they have claims of their own. Both sides are required to submit full financial disclosures. This is going to include income, assets, debts, and expenses. If your spouse is refusing to provide information, your attorney can file motions to compel or even request subpoenas from financial institutions. Sometimes we need to establish temporary arrangements while the case is pending, especially when it comes to child custody and visitation, who stays in the home, who pays what bills, or even access to marital funds. These are short-term solutions to help stabilize your situation. In Florida, most counties require parties to attend mediation before going to trial. Mediation is a structured negotiation session, often with a neutral third-party mediator. Sometimes it works, sometimes it narrows the issues, and sometimes it confirms that a trial is necessary. If things don't resolve in mediation, the case moves into more discovery, a formal process for gathering evidence. This might include interrogatories, depositions, requests for production of documents or records. This stage can take time, but it's critical for building your case. If no agreement is reached, the case moves forward to trial. Each side presents evidence, questions witnesses, and makes legal arguments to the judge. Then, the judge issues a final ruling on all contested matters. When people hear contested divorce, they often picture drama, yelling in court, drawn-out battles, skyrocketing costs. It doesn't have to be that way. The goal is not to win at all costs. It's to create a clear, strategic path to resolution, even if the other party isn't playing fair. One client wrote, "I was terrified of going to court, but Vanessa turned chaos into calm. I felt informed, protected, and heard every step of the way." Another described the experience as structured, honest, and empowering. It wasn't easy, but it was necessary, and I didn't feel alone. That's how we approach contested divorce. We prepare you, not just legally, but emotionally for what's ahead. We protect what matters most, and we push for resolution without sacrificing your rights. Contested divorce may be the right path if one spouse refuses to cooperate, if there are complex financial assets, if the parenting plan is in dispute, or if you suspect dishonesty, coercion, or abuse. It's not the easiest road, but it can be the safest, most effective one when other options just won't work. So how do you know which path is right for you? Let me give you a simple framework I often walk clients through. Can you and your spouse communicate openly, respectfully, and in good faith? If the answer is yes, you may be a good candidate for uncontested or collaborative divorce. If conversations always escalate or you just can't get a straight answer, you may need a contested path. Are you truly in agreement about the key issues? That includes who gets what, parenting time and responsibilities, child support, alimony, or no alimony. If you've only had surface level conversations, or you're assuming things are going to work out, you may be surprised once the paperwork starts. Is there trust and transparency, especially around money and parenting? If you don't feel confident that your spouse will follow through, provide honest disclosures, or even just stick to the plan, that's a huge red flag. In those cases, you need a process that offers protection, not just speed. You don't have to have all the answers today, but asking those 3 questions can reveal a lot about the path that's right for you and whether you're emotionally and legally ready to begin. One client told us, "I thought we were uncontested until I saw how many decisions we hadn't actually made. Once I realized that, I was able to ask better questions and get real clarity." And that's what this is really about. Not rushing into divorce, not labeling yourself before you're ready, but getting the information you need to make the next right move. If you're still processing things emotionally, or you're unsure what your answers to those 3 questions are, start with our divorce readiness quiz. It takes less than 5 minutes and it's completely confidential. And it'll help you figure out where you are emotionally, financially, and legally. You'll get a personalized result and next steps based on your answers. And no matter where you land, you'll have more clarity than you had 5 minutes ago. Or if you're ready to talk with someone now, you can book a free case evaluation with our intake team. That's a 10-minute phone call to walk through the basics of your situation. From there, we'll match you with either a free 30-minute discovery session with our client engagement specialist or a direct consultation with one of our attorneys if your case is more urgent or complex. There's no pressure, no commitment, just real guidance based on where you are right now. Because no 2 divorces are alike. And no matter what path you choose, uncontested, collaborative, or contested, you deserve a plan that fits. So take the quiz or book a call. Either way, you're taking a step toward peace, protection, and clarity. Here's what I know after 2 decades of doing this work. Nobody ever regrets getting clarity, but a lot of people regret waiting too long to get it. In our next video, we're going to tackle one of the biggest questions people have when thinking about divorce. How much is this going to cost me? We'll break down legal fees, hidden expenses, and what you can do to control your costs, no matter what type of divorce you choose. I'm Vanessa Vasquez de Lara with the Vasquez de Lara Law Group. And when family problems become legal problems, we're here to help.